You rely on that.
Okay, welcome, folks. This is House Corrections and Institutions Committee. It is our 2 o'clock meeting. We're working on S-109, which is a Senate bill that's over in House Judiciary Committee. But we are looking at the county courthouse situation when they need state capital funds and what the process is. We may be offering an amendment to current language that their capital reserve fund would need to be looked at also in conjunction with their capital plan. So this is also Wednesday, April 16th. So we have with us our current court administrator, Terry Corzone. So welcome, Terry.
Thank you, Madam Chair.
Identify yourself, please, for the
Terry
record.
Corzone, State Court Administrator. And thank you for the opportunity to come and comment. I have seen the language and I also watched the recording of the assistant judge testimony yesterday. So I have familiarity with that as well. And I'm happy to, I guess, give my comments on it if that would be helpful.
That would be very helpful.
Great. And I do want to also thank Assistant Judge McKeeman, because in all honesty, before her testimony, I think last week before you all, I wasn't aware of the capital reserve fund that counties might have. I know I did make inquiry of whether there was funds in the county budget, but not knowing about the capital reserve fund. So that was very helpful. And in the context of looking at the statutes that describe the capital program and the capital reserve fund for county courts, that's kind of the basis for my comments just regarding the language, if that would be helpful. And I did bring those statutes in case people would like to also see them, if you'd like.
That would be helpful.
Okay, great. This is to add to the other statutes that I handed out before. But this has to do with a description and some of the questions that came up about the capital reserve fund in county government. So I think just starting first with the two statements that are added, or the two sentences. It's talking about adding 2 criteria to the list of criteria that are presently in Title 4, Section 39. And the first one is whether the funding request is consistent with the county's capital program. I'm sorry, with the county's capital plan. And I guess one comment is just when you look at Title 24, 133, and it's actually Part E on the second page, and it's E3. That's where this is referred to. They call it a capital program versus a capital plan. So that was just one thing I thought if you wanted to be consistent with the actual verbiage. So whether the funding request is consistent with the county's capital program. And then I thought to add, if any, because as was discussed yesterday, they're not absolutely required to have the county, the capital program or this reserve fund, because it says may include a provision for a separate reserve fund. So I just thought, again, to be kind of consistent with what the statute is now. And we learned from the assistant judge testimony that not all counties have a capital program or a capital reserve fund. So that was one comment just in terms of the first proposed, or the first sentence.
So for the committee, are you following this? Because she's referring to this document here.
Yes.
Okay.
Quality of notes.
So is there, pursuant to a capital program versus capital plan, there is a difference, I would think.
Well, and there is actually in the other statute that I've provided, this is Title 24, Section 4430. It gives more definition of a capital plan or capital program. It says a capital program. Yeah, and this is where the capital program is more particularly described. And that's in 4430A.
Yes.
But it says a capital program is a plan of capital projects proposed to be undertaken during each of the following 5 years. So again, because they refer to it as a capital program, I just make mention of that just so it's consistent.
I mean, to me, just logically, a program consists of the plan and the fund, right?
Yeah, I'm just pointing out because all the statutory references are to capital program to make mention of that.
Because you can have a program without a plan, they've got to help you.
So, and I'm glad to see it says capital budget program.
Yeah.
That's even more specific.
Would it be helpful for the language to reference these two sections of statute
Possibly.
instead of just saying it? So side judges are really clear that there's, because this is in, we are amending Title IV. The two sites that we are looking at are Title 24, but they may not look at. And it might be better to cite
To those
those two sections.
That very well could,
And then you really are clear, and then they themselves, side judges would need to look at Title 24, not just Title 4 that we are amending for their own,
and
just to be clear, because I'm sure they're aware of Title 24, Section 133, because that's dealing with assistant judges in the county tax,
So
but they might not be as aware with Section 4430 under Title 24.
I think that's something in terms of, I know they had asked for more time to kind of fine tune the
Right.
language. This would be an example of how that might be helpful to.
To cite those actual two sections of law.
Mhm.
So we were not wrong yesterday when we said that it was a requirement already.
Well, I don't know that I don't see, because it says may.
Oh, man.
As may,
Gotcha.
So I didn't know whether you'd want to say if any also.
Yep.
It's a criterion.
Well, you may want to say shall.
Shall.
Yes.
That would require an amendment to Title 20.
I understand.
yeah,
This goes on, I finally caught up with you. This even says for 5 years.
Hmm.
Projects proposed to undertaken during each of the following 5 years. That's right where we thought we wanted to be.
yeah, because quite often what we were hearing from the side judges, they do it in blocks of 5 years, and then so it'd be like 20 to 25, and then the year 25, they say, oh, well, we're gonna have to do 26 to
31.
31, instead of in 1921, they should also be doing 26. So every year they would add a year.
And I get the impression that they would very much like to, because there's oftentimes turnover in the
Right.
assistant judge positions. And then I think with the pandemic, I'm sure that wreaked havoc with everybody's budget plans, but I think, and they mentioned Utah College, which is scheduled in June, is a time when they meet and have kind of in-depth discussions as a group. So that, I make mention of that for the first sentence. And then the second sentence, another criterion, the status of the county's capital reserve fund, I think, which I think makes perfect sense. That is, what is in the capital reserve fund? What's the status of it? The next part, whether the county has made sufficient annual contributions to the fund. If this is a criterion that I'm supposed to be evaluating, I really would not be well positioned to make that determination, whether they have made sufficient annual contributions, because their county budget and capital reserve fund covers things more than just the courthouse. So I didn't know if the point was to say the status of the county's capital reserve fund and whether funds in the capital reserve are available for the request. Maybe if that's what it comes down to, maybe modify it accordingly versus me deciding whether or not their contributions are sufficient, because I really wouldn't
Right,
be in a
it's not-
position.
I think the concern was, are they putting funds into the capital reserve fund? And how do you address, how do you find out if they're on a, I don't want to say annual, but on a fairly regular basis, are they putting funds into that capital reserve fund, or are they just establishing it? One year they put a chunk of money in it and then they just leave it
Right, and then
and
that,
not keep adding to it.
and that listing that Judge McKeeman provided, showing how it varies so much across the counties in terms of whether there's a fund or not, how much, and then annual contributions, et cetera. So
But in specific, if you're putting a 5-year plan together, that infers you got some kind of a cost estimate. And if you got a cost estimate, you've got to have a plan to get to that amount of money. So
Not necessarily.
Well, that's what we're asking, is
Right.
that you're thinking ahead and you're trying to put it ahead, as opposed to just assuming that the state's gonna pick up the tab.
Or even as you said yesterday, 5-year plan is rolling. It's not established that you get the end of the 5-year plan. So anyway,
And I think section 4430 does make reference to the need to have an estimate done, the method of financing, all the details for that process.
So I don't want to put you on the spot, and I don't want to put Greg on the spot either. So if there was a situation where a county came to you wanting to have state money for a project, and this, some form of this was in place where you had to see what they had for a capital plan and what they had in their reserve fund. And it was determined somehow that they hadn't been putting any money in that reserve fund for 4 or 5 years. Would that set off some questions?
Well, to be honest, right now in the for section 39 list of criteria, it includes at the end, any other criteria as deemed appropriate, which certainly now that there's an awareness about this, I feel like that would definitely fit within that. That's already in the statute. And yes, I think it would prompt that inquiry, because I would anticipate that's exactly what you all would be asking too.
If we knew about it.
Right, but to me, that would be part of the transparency and should be part of what is presented.
I would think that would help you folks make a decision on whether or not to include that as a capital request for the capital bill. That if they've been diligently putting money aside and they've been updating their capital reserve fund, and they do come to you folks, the court administrator, for a request, I would think that would give you more information, and also the legislature more information. This is a legitimate project, and yes, this county has been putting aside money. They do have a plan. This is part of their 5-year plan, but it's just the cost has increased so much, they just can't absorb it with their tax base. That's legitimate.
Whatever the circumstances are.
But if they haven't updated their 5-year plan
mhm,
and they haven't put money in their reserve fund for 5 or 6 years,
mhm.
and then they're coming in and asking even for 200,000 for a project, it could be, well, wait a minute here.
Well, and I think you're laying out a roadmap for their awareness when they do work to make sure that people are aware of this resource, this process, and take advantage of it as an opportunity. So I think this exercise to me has been really helpful to be able to have more information to make the evaluation. Keeping in mind that it's my understanding that, because as I mentioned, I think this is just I've only been in it 2 years, so this is the second time. Last year we didn't have the request. I don't think historically there have been that many requests. And Greg did research in response to your question the last time about what are examples, and he made mention of the Americans with Disability Act renovations and the HVAC. So he does have the details on that, if that would be helpful to you.
I'd like to hear that, but I know Mary has some questions.
It's just a brief. Would it be beneficial? I know yesterday the side judges were kind of indicating, could they have time to, as an organization, kind of meet? Can they meet with you at that time as well, if that was decided? So that you folks actually come out with what will work, and then they come back to us? I mean,
They could do that, but I also have another thought, so that we don't lose this. Come next session, be up for us to remember that we've asked everyone to get together. If we put in this language, some form of this language, they need a reserve fund and a capital plan. And we have the law, we have that change take effective July 1st, 26.
Mhm.
So it's there,
Mhm.
but you've got between now and July 1st of
So if you-
26.
so if they had changes.
We can deal with it next session. They know that it's there. It will be effective a year from this July.
Which I think with your biennium, you wouldn't be having the capital budget.
But we would have a BAA,
The
not a
BAA.
capital budget next year.
Right,
We
okay.
have that, but it's, at next legislative session
Mhm.
to hear back from side judges and you folks, and it would give them the time. But at least we do the amendment, we change the language.
Mhm.
Then, but that doesn't become effective until July 1st of 26.
So just-
it gives everybody a warning.
But I just wanted to be respectful of all of you to have the opportunity to discuss in depth
Right,
what the details should actually be.
right.
Oh, that, I would appreciate that. And in the meantime, we have that catch-all provision that allows me to look, if there is a request, to look at
Everything
the
else.
reserve plans or fund. Okay,
Joe?
And then just so I'm clear, specifically on lines 14 and 15, it'd be your preference that the second portion of the sentence weren't there.
well,
Well, it's how, if somehow reword it, so it's not her making the determination of whether they have sufficient.
Sorry?
Where are you?
on 109, line
Okay.
14 and
Okay,
15.
but I.
Oh, I'm sorry.
If he was on what page?
Oh, okay, page 1,
Yes.
sorry.
The question was that the court administrator wouldn't have the ability to determine whether the county has sufficient annual, if they've made those sufficient annual contributions. So we can word that differently. The intent was to make sure that the county has been putting contributions into that reserve fund. So Terry's concern was that the way it's worded, that the court administrator would have to make that determination if they were.
Well, yeah, and we don't expect for you to be expert on 14 county budgets. So that sounds a little onerous,
Right.
but we're just to read the status of the county's capital reserve fund. Stop.
But in testimony that we received, they could have a reserve fund, but they haven't made contributions to it in 4 and 5 years.
And
So we want to make sure that they're making contributions
Okay,
to it. It's just the way it's worded. We can wordsmith that.
okay.
I mean, if the 5-year plan is rolling annually, then you could say enough money is being set aside to meet the 5-year plan, right?
We'd work with Eric Fitzpatrick to figure out some language.
right, and I'm happy to talk with Eric also.
That maybe brings you back to another question. And maybe it's just a misunderstanding. So they can put up to a certain amount in each year. But is there a cap on how much can be in overall?
Three-quarters of their operating budget.
Yeah,
That's-
5%.
Yeah, so
For the capital reserve fund.
if they're already there.
10% for the operating reserve fund.
So
I
obviously,
thought so, but I just want to double check.
and so that number is going to be vastly different county to county.
Right, but the issue was, we want to make sure that they are updating their 5-year plan.
Mhm.
And that they are putting in contributions in the reserve fund, because they could say, and I'm not saying they would. But they could say, oh, we have a capital reserve fund. Yeah, well, it's 10 years old and you haven't put money in it for 10 years. You know, and you're here asking, and you're here asking the state for money when you haven't been putting money in there
Yeah.
for 10 years. I mean, that's an extreme situation, but that's what we're trying to address here.
I understand that. In practice, at the end of the day, and I don't think in the whole scheme of things, it's a lot of money, but it's either gonna funnel. If you're going to Lake Champlain or the Connecticut Basin, it's either gonna go be reflected in your state taxes or your municipal taxes. Because the county budgets go to municipal.
Somebody's gonna pay for it either way.
Correct.
Yes.
And
But the issue is, they haven't been putting money in it.
Hmm.
And they haven't been updating their capital plan. Then they come to the state asking for state money. That's the issue,
And the reference to 75% is in that part E3,
right?
just for information.
So Will, did you have something?
No, I think.
Right?
I don't know if this is relevant, but I believe we learned in testimony the other day that some counties put some of this money towards the sheriff's department.
Mhm.
Is that a big enough portion that that's gonna mess up measuring how close we are to getting?
Well, I think in their program or plan, it would spell out what the funds are intended for, so you could see the breakdown.
And so that would be in there too. Okay.
That should be.
Yep.
Now, we're not putting you in an uncomfortable position because you work well with everyone, but by kind of walking through this with them, you're not.
Oh, no, I think that would be really helpful to
Right,
me.
yeah, well,
And
that's what I thought. So if someone's missing something, maybe with all of you collectively can come up with everything you kind of need.
Oh, no, I'd be very happy to, and they're wonderful to work with, and
Oh, yeah, they're all great, so.
Right. Am I reading this correct, that VSA or 24 VSA 4430, this was adopted in 2003, the last page?
Looks it,
oh, well, added 2003.
it was added.
Been amended.
Okay, it was amended then. So since 2003, there's been a directive, as I see, shall list and describe the capital project, which I would read this, and I'm not good at it, but this is saying if you see capital project coming down the line, you need to be doing this, or don't come to the legislature. This is giving us a heads up that we're gonna need to put money in a future date.
Well, it would justify them asking for state money.
Right, right. And in the absence of that, we're not in a position to do that, because in fact, we're always looking to cut. We're not looking to grow.
I mean, I think it's just a consideration, right? You have a county running a $400,000 budget. The most they could possibly reserve would be 300 grand.
Right.
So you could conceivably take care of smaller projects,
Exactly,
but somebody needs a new courthouse or a major renovation.
right,
They could never do that on their own based on what they're, unless they're bonding it.
No,
right, exactly.
Based on what,
No.
what,
But if, for the counties,
zero in statute.
the counties put zero away and they come for a $200,000 project, you're like, what, you haven't done your due diligence.
Yeah, so, I mean, you could cite those courthouse power backups from this year, and to your point, Kevin, we're in an environment where it appears as though we're gonna be expected to do the same or similar things with fewer dollars.
Right. So this is just really to protect the courthouses so that you're looking for enough to do something for you, because you can't collect enough money to build a brand new courthouse.
And the Woodstock Courthouse did vote a bond, a $2 million bond, and they made their.
Oh, and that was an additional thing, right?
Yeah.
Okay.
Right, and then the capital budget shall list, that's their annual
Yeah.
fiscal budget.
Yes.
So they're required to do that.
Yes.
The 5-year one, it doesn't say shall for that.
Yeah.
Yeah.
So Greg, could you go over some of the projects there that have come in? Is it those that have come into the legislature for money?
Yeah,
But some of that is ARPA, right?
no, actually.
No? Okay.
So for the record, Greg Mullins, the Chief of Finance and Administration for the Vermont Judiciary, and since unification, when the state kind of subsumed the operations of county courthouses, there was a appropriation of capital money in 2012 and 13, $200,000 each year. So a total of $400,000 for ADA accessibility issues at the county courthouse.
Now it's across all of them.
It was across all of them. It was appropriated to BGS and they managed.
They
to fund
managed it.
in the projects. I don't have the details of exactly what was purchased with that, but I do know the counties that it went to. It went to Orange, Essex, Washington, and Grand Isle for some sort of ADA ramps or widening doorways, bathrooms or something. And then in 2014 and 2015, in that biennium, there was 88,000 bonded money given to Windsor County for life enhancing systems, safety, life safety requirements, which was a fire alarm system and some sort of electrical device redundancy. And then the pandemic money hit, and I was here for that. And we did make an ARPA request for HVAC for those 12 buildings. We did not actually get the ARPA money. We were given a general fund one-time dollars as requested, but it was not federal funds. And so we went around and had a mechanical engineer assess each building. And in some cases we upgraded, in some cases we installed HVAC. And we've done a number of things that might not be considered, well, they weren't considered capital bonded dollars, but we have assumed all the responsibility of the computer systems, which is not just the computer equipment, but the wiring within the building, printers, the copiers, the phones now are part of the computer system, security cameras.
Their IT system is part of your new system.
Yeah,
Right.
and even
Okay.
right down to like the badge swipes, the access doors in many of the county buildings, we have purchased that because it's enhanced the security of our staff and visitors to the courts.
versus keys that could get passed out.
Right.
Yes.
So yeah, we've been, the state has been investing in these buildings for some time.
Mhm.
So he just mentioned that they didn't get ARPA money. Do you remember why they didn't get ARPA? No, okay.
I don't know why you won't get it.
My understanding was that we were just, not the highest priority. We're outside that $1 billion, but they were able to fund it one time. So it was a small enough
Yeah, I
request.
just-
So it's general fund.
Yeah, I didn't know if it was a strategic thing that we had to move money around a certain way, but I was just curious. Thank you.
I mean, I don't want to tie the hands of the side judges. But if they're coming here for capital improvements and they want to keep ownership of the buildings,
You have to have skin in the game.
they have to have skin in the game, but also they have to make a legitimate request.
Mhm.
That, yeah, we've been putting money aside. This is what we have in our reserve fund. A portion of this is for the other buildings that we own and that we're responsible for in the county.
Mhm.
This is a tax base that we work with our county. This is the amount of money we've been putting aside on a yearly basis or regular basis to keep track and keep up with our 5-year plan. But this project is really needs to get done as part of our 5-year plan, but we just don't have the capacity. They got to make their case.
Mhm.
And I think in order to make their case to the entity that makes the decision, the entity needs to know all the moving pieces. And I think there was a couple pieces here that were missing. One, they had to have a capital plan in place. Two, that they need a reserve fund and that they need to contribute to that on a regular basis. If you don't have that information, the entity that's to make the recommend, you don't have that information, you got one hand tied behind your back. And we as a legislative branch do as well.
So I really appreciate the increased awareness, certainly for me. And I feel like there's very strong leadership in the Assistant Judge Association and that they will want to meet and make sure this is crystal clear so that there's, for any county that might not have been aware to, from that point forward, work along the lines of what you're describing.
Huh?
Yeah, just reading this, I wonder, it looks like the budget is required for the counties, but that there may also include the provision for a separate reserve account for capital construction.
Yes.
Is it better if that's a shall? I mean,
That's what we
yeah.
That would be another amendment, though, that would need.
That is touching municipal and county governments, and it's a touching assistant judges, which then would trigger GovOps to take a look at
Mhm.
this.
Just say
It
government.
can't be done in isolation.
Because right now it's, if they want to, they can, but they don't have to.
I mean, we could broach that with GovOps, but that would be something GovOps would have to weigh in as well. And I don't know if we want to do that in the middle of April for legislative session. Just putting that out on the table. And put it into a judiciary bill. It's not in our committee.
I understand Connor's point, but I'd agree with you, Alice. Because it would just go there to hang out on the wall, probably to the end of the biennium at that point.
It might. It's gonna
Yeah,
add some
exactly.
confusion. Brian?
This probably isn't realistic, but when we talked about, there's a federal match, 5-1, something like that. Is there enough variability between counties and between projects that would be unrealistic for this? To make it a certain kind of match across all of it? Your municipality puts in $1, we kick 5. Or is there too much variability in the county's ability in the projects they're doing?
Oh, gosh, I think there's wide variability
Yeah.
from county to county. You're looking at Essex County and
Yeah.
Chittenden County.
Yeah,
Yeah.
yeah, okay.
So what if we clarify the language in number 1, which is line 12, that we cite 24 VSA, section 133 E3. That would be right. And also 24 VSA 4430A. that we cite that. That's what we mean by consistent with the county's capital plan program. That explains what the program is. And also explains that it's 5 years. It should be 5 years. And those are the two, and that there should be maybe a separate reserve. And number two, the thought is, what's the status of that reserve fund, which is okay, but the question is, we can work on language. We want to make sure there's some dollars that have been contributed, that they've put some contributions into those reserve funds, and we can wordsmith the language so it doesn't look like court administrator has to make that determination if there's sufficient funds.
So the status of the county's capital reserve fund and the amount of annual contributions to it,
And the amount of annual contributions to it.
something like that. And then, like you say, with Eric to wordsmith it.
So for language changes, does that make sense to folks?
Mhm.
To work with Eric Fitzpatrick on that?
Mhm.
The other thing I'm thinking is what Mary has, and so then the other thing would be that this change would be effective July 1st, 26.
Mhm.
And then to pick up what Mary is talking about, to make sure that the court administrator and the side judges work on this, we as a committee can send a letter of intent to the court administrator as well as to the side judge association, explaining what our intent is between now and when the law takes effect. You folks work together and work through, we can wordsmith this, but work through how you want to address capital projects
Mhm.
going forward, or work with this language that will be effective July 1st of 26, how that would play out.
Mhm.
So that it gives time for the side judges that they requested to work through this.
Mhm.
And then a letter of intent would also encourage all parties to sit down and work together.
I think between you and Mary, you get this all solved.
Does that make sense to folks?
Perfect sense.
Yep.
That makes perfect sense. And I'm sorry, I should have thought, I was thinking, oh, maybe I could text one of them to say it.
I was going to say. are
Yeah, and I
any of the side
apologize that I didn't
judges
think of
on
doing
it?
that.
They're live streaming.
Oh, good, okay.
They've been notified they're live streaming for this.
They would like you to know that in addition to the courthouse and the sheriff's, there's also county roads and bridges.
What?
Oh,
That's new.
That would be news to me, but
County roads and bridges.
It's really new to me.
Would it be a
County roads,
historic
bridges.
bridge or something? But if it's county roads and bridges, they gotta work with the transportation.
I was just going to say, we can pump kick that to transport.
Walker can.
Add that to the T five.
That's really interesting.
yeah.
Where does the county on the road?
That was probably
I
last
mean,
200
would that be
years.
like in like unorganized?
That was probably 200 years ago.
Yeah, because New York State has county.
Yes, there's
roads.
Roads on their property.
Yeah.
I have no idea. This is just making me curious.
So we'll rework the language with Eric Fitzpatrick. We'll get it out to everyone, you folks as well as the side judges, and then hopefully go from there. But I think if we give a year for folks to work on this, and then next year, next biennium of January, if there needs to be tweaking of the language, we can do that. Or the language works
Mhm.
and you folks have figured out a way to do this, and the language doesn't have to be changed, then it goes into effect.
Yep. Sounds like a plan.
And would it, in the meanwhile, make sense to at least ask the question on this list as to why in some cases there's literally nothing?
Did we already
We'll
ask them?
probably have that discussion when they get.
Well, I know, it's just that it may shed some light on what words should be in here. We find out why some have participated and some haven't. Right.
But didn't we ask them to ask that
Well,
yesterday?
right, Carolyn Partridge mentioned they don't have a reserve fund because they plan ahead in terms of what projects they see coming, and then they budget for that accordingly. So they don't do it through a reserve fund.
Yeah.
And they can make that case. If Wyndham County comes before the court administrator, they could make that case that that's how they have been doing it. Because
they-
that's why there's a may there in terms of a reserve fund. It's not a shall. So if you change that may to shall, you're gonna require Wyndham County to have a reserve fund. And that's not how they're budgeting for capital projects.
We'll have a thorough discussion of that, and then we can.
I'll give you one more.
No, I think this is so helpful, and I think it'll be really make everything much smoother and easier to evaluate in future years.
And then you're all on the same page too.
And I don't wanna pick,
No,
I really don't wanna pick, but in one of the documents that we got yesterday, it showed the Lamoille County Capital Reserve for FY 24-25 was $378,465. They did have some expenditures that they were putting out for county expenditures for 24-25. There was some roof repair for about 14,000. There was a ventilation for one of the buildings for 9,000. Solar protected window film for 3,400. Courthouse railing refurbishment for 3,500. Snowplow for 10,000. And spring maintenance, building inspection and maintenance for 10,000.
don't know if that's useful. This is.
So they used some of the 378,000 for that, but then they asked for 190,000
and that
for a
only,
generator.
and that only represents 47%.
But this is information that you folks didn't have.
Did we give our court administrator all that we received yesterday? So they've got it.
The documents that we got.
They're posted.
I was gonna say, I think I really
I
copied.
mean, I don't want to pick on Memorial because we've already put in 190,000. It came as your request to us, and we put that in. But then when you see this, it's like, well, if you had had that information, you would have asked, I'm sure.
And we did inquire just in terms of their budget, their county budget.
And we did too.
Yeah.
Yeah.
So I think this is,
The other thing, Terry, I have a question on the current language on the capital budget request, county courthouse. On line 7 and 8, each year before October 1st, they come before you for any county requesting capital funds for its courthouse or court operations. And I want to make sure that the interpretation of court operations is not for the operations of the court.
for operations expenses.
Because capital funds are not used for operation expenses.
That's my understanding, that it would be strictly capital improvements to, I guess, facilitate court operations, such as the generator to,
Make sure the court can function.
right, but not
But the
court
wording,
operations expenses
the
otherwise.
wording has to be, I think, better because future legislators may not be aware of what the intent is.
I mean, I'm just, because capital funds can't be used for operational expenses. For an operating budget.
Right.
And I just don't know if while we're changing something, that could be clarified.
Well, would, for example, a generator be considered a capital improvement? Is it?
Yeah.
Oh, it is? Okay.
Yeah, absolutely.
Oh, okay.
Yes.
Yeah, it would be. I'm just concerned on the term court operations. And I know you need an upgrade. You know, because maybe you need more security for the jury room, or you need a holding cell. That's dealing with how the judiciary would operate in that courthouse. So it's not your operating expenses. I just want to make sure that court operations is not interpreted that capital funds are going to pay for operating expenses.
Court operations could also include hiring more people to operate. So it does get a little.
I just don't, why don't you think about that maybe, Terry, a little bit, Greg, and then.
Maybe even talk with Eric, because I don't know if we say or quote operations, but not operating expenses, something
Yeah,
like.
Something like that.
Just to be clear, it's not operating expenses.
He's good. Around
Maybe
here,
I'm overthinking it, but
Yeah, but in
Oh, no, I think
future,
that's
future years, people aren't going to know what our intent was unless it's clear.
maybe around here. Being around here, Terry, we only do two things, make things better or make them worse.
Usually worse.
so we'll connect with our legal counsel, get a new draft, and then we'll distribute it to you folks as well as the side judges. And we'll go from there.
Yeah.
Exactly. I'll also email Eric if I can be of help when he's doing it.
Right. And then the thinking is there's a judicial bill, S-109, that's in Judiciary Committee. And we could add this language to that bill.
And we've testified a number of times on that bill, because that's also been evolving a bit, so. Seems it would be,
I can follow up with the chair of the committee.
okay.
Thank you.
Thank you, guys.
Thank you.
Thank you all.
Thank you so much.
Thank you for your patience and.
Thank you, Greg.
Enjoy the rest of the day.
Me too. I'll see you tomorrow.
Yeah, thank you for coming in. I appreciate it.
Pleasure.
Thank you for the cookies.
Yeah.
Okay, so let's shift gears back to our most favorite bill. Page 32, MOUD.
PIA.
What we really want to talk with Ashley Berliner, who is with the Agency of Human Services, DEVA, talking about Medicaid and how the 1115 waiver would be working within DOC and how Medicaid would then kick in. So Ashley, why don't you come on up? I know we're running a little late, but didn't mess up your schedule too much. As we kind of flip both of you a little bit.
What these?
So I don't, if you were here at the very beginning of the session, right?
We should ask our guest if they'd like a quick.
Thank
Yeah.
you. I'm good, thank you.
Anybody over there?
No, we're fine.
This guy named a couple of them.
What?
No, it's okay. So we've been looking in terms of medical care for folks who are incarcerated, medical care in general, and also the MOUD for substance use. And with the 1115 waiver, 90 days prior to someone re-entering the community, they could qualify for Medicaid reimbursement. And it would be DOC that would be reimbursed, but the person, it's a way to have the person apply for Medicaid and be approved, be on Medicaid for those remaining months prior to their release. And then when they're released, it's that continuity. They would still be on Medicaid. So we need to know how that process works in the DEVA world, because you would be administering that. And what would be required of information from the person who's incarcerated in order to apply and qualify for Medicaid? So those are the broad questions that we have. Does that make sense?
Sure, yeah. Yeah.
So identify yourself for the record and welcome.
Hi, I'm Ashley Berliner. I'm the Director of Medicaid Policy for the Agency of Human Services. I also oversee the 1115 Global Commitment to Health waiver for the state of Vermont, of which the reentry waiver authority sits under. I have been to this committee in the past to talk about this waiver authority a bit, but just to refresh everyone's memory, we had this authority approved in July 2024, and we are aiming to launch the first Medicaid dollars flowing through correctional facilities on January 1st, 2026. As you can imagine, it's an enormous undertaking to bring Medicaid into the facility for the first time. It's a really good opportunity for us to do that. And we're really grateful for the opportunity from the federal government to be able to receive federal match for the first time. We are focusing on the adjudicated population only. So individuals who are there but not sentenced are not eligible for the Medicaid match, though they will receive the same services. We're really looking at this as a way to get federal matching funds into the facility. And we're enhancing some of the services, but a lot of it is already being done today. So as you said, 90 days pre-release is when this kicks in. And at that 90-day pre-release period, during that 90-day pre-release period, we will be connecting individuals through the Vermont Chronic Care Initiative, VCCI, caseworkers to help them with their case and make sure that they're connected with everything that they need, making sure that they have appointments scheduled on the outside and are getting their care coordinated to the extent possible.
So say that again, that there'd be caseworkers from DIVA working with caseworkers or working with the inmate directly?
Yes, from AHS. So VCCI, which is the Vermont Chronic Care Initiative. We have caseworkers already all over the place that work with our high intensity Medicaid population. And this would be bringing VCCI staff into the correctional facilities to focus on this pre-release population. So we have one VCCI caseworker per facility, 6 in total.
So they would physically go into the facility.
It's going to vary depending on the individual inmate. We've heard DOC has conducted focus groups with some inmates who have said some prefer telemedicine, telecommunication, and some would prefer in person. So I think that's going to vary. We'll have the capacity to do both.
Okay. Questions on that piece? So that would be working with the offender directly to get them signed up.
Signed up for Medicaid? Is that what you're asking about? So we're actually pretty much at entry. So this is, I was just talking about the 90-day pre-release as they're leaving the correctional facility, but we're trying to get people signed up for Medicaid as they come into the door, really. We want people who are there, even if they're only there for a few days, we want to be checking and seeing if they are on Medicaid. If they are on Medicaid, we'll have to suspend their Medicaid, which we're actively building functionality to do now. And if they're not on Medicaid, we want to get them on Medicaid. So that's not necessarily something that's going to start at that 90-day mark. It's a goal that we have.
So you have two things going on. You really have two things going on. Is it with the same caseworker that you're going to be putting in or be available for each facility? You get, what I'm understanding, there's two things. The 1115 waiver allows a person who is incarcerated 90 days prior to their release to apply for Medicaid and be eligible. If they're eligible, Medicaid kicks in. And then for whatever health services that they have in that 90-day window, Medicaid would reimburse DOC. Is that correct? Is that part of the 1115 waiver?
The mechanisms of the reimbursement are a little more complicated than how you just described it, but for the purposes of conversation, I think, yeah, I think that is fair to say. We, though, are really thinking about the reentry piece separate from getting people on Medicaid in general. That's not part of the reentry initiative that we're working on. We want people to be on Medicaid, and this is literally a captive audience where we can make sure that they're applying and poised when they do enter back into the community to be on the Medicaid program. So that's not the VCCI staff necessarily that are doing that. That's DOC caseworkers that might be helping with application processes.
At the front end.
Yes.
Okay, so, because you got two things going on here. The 1115 waiver is only for those folks who are sentenced. And it's 90 days prior to their release date. That's the 1115 waiver. And that would allow them to sign up for Medicaid while they're still incarcerated.
That will allow us to get federal funding from Medicaid.
Okay.
So it's totally separate from them
Okay.
signing up for Medicaid.
So that would allow Medicaid dollars to go to DOC to pay for the health care for those particular individuals, 90 days in that 3-month window. But that doesn't mean when they re-enter because of the 1115 waiver, that does not mean that they would automatically be set up on Medicaid.
We expect that most people in corrections are Medicaid eligible.
Correct. So I think I know what you're saying, but I'm trying to, maybe I can't explain it well. You got the 1115 waiver, 90 days prior to their release. DOC will be able to get Medicaid dollars for their health care. The other piece is we want folks to sign up for Medicaid while they're incarcerated. So when a person becomes incarcerated right now, if they're on Medicaid, they get canceled.
Suspended is where we're going.
Right, but right now, prior to going to suspension, right now, a person who is incarcerated, they lose their Medicaid. And what happens, this is what we understood this past summer and fall. What happens is with our system within DIVA, there isn't the opportunity to suspend their Medicaid. Their Medicaid gets canceled. So when they re-enter, they have to reapply. And what you're looking at now is not to cancel the Medicaid coverage while they're incarcerated, but to suspend it. Is one part. Correct?
So we do not have suspension functionality right now today. You are correct about that. And we are building that actively to turn on at the same time that the reentry benefit turns on. So that will happen simultaneously. What's happening today is that people are remaining on Medicaid when they're in corrections unless there is some proactive report to DIVA saying that they're incarcerated, which isn't very common. Most people are just actively still on Medicaid. They shouldn't be. They should be suspended. We don't have that functionality. But when they leave, they're still on Medicaid. So it's really random
Very random.
it is. And when DIVA is notified of incarceration status is quite random as well. It could come up in renewal if someone just happened to have the renewal date at the time that they were incarcerated. It could come up if someone was in inpatient hospital, and we would find out that way. But in general, we aren't going in and looking at rosters of who's incarcerated and terminating their Medicaid eligibility.
But if you know that they're incarcerated, one way or the other, the information got to DIVA. Right now, is their Medicaid policy canceled? Or is it suspended?
It's terminated.
It's terminated. And then when they re-enter, regardless, I don't want to go down the 1115 waiver. When they re-enter, the person has to reapply.
We are not as good at it as we will be, but we are working even today to get people to apply on their way out. So if they're not on Medicaid today, we are working, and there's close coordination between DOC and DIVA to make sure people are applying on their way out. We're working to make that really seamless, and it will help a lot by having the suspension functionality in place.
Interesting.
Do they have the technology to do that?
We will. We're building it.
They're building it. There was money.
I've been in my
budget for it.
29 years through so many technology changes that I've not heard. I get a little concerned with that.
Me too. It's concerning.
Especially where you'll be connecting with the DOC on it as well. But I'll stay hopeful.
No, I share your concern. The IT projects are fraught. We are really optimistic that we're going to get this in place. We have a really good team working round the clock, basically, on this to connect multiple systems. And that's a big part of the work is we have the DOC WellPath electronic health record that has to come into play. We have the MMIS claims processing system, and we have Optum, which is our like eligibility engine through which is how Medicaid members come in the door. So all of those have to talk to each other. It's a huge undertaking. It is certainly something that we are paying close attention to make sure that we keep on track.
So if a person becomes incarcerated, when a person becomes incarcerated and they're on Medicaid, and whether they're a detainee or a sentence, and they're there, a detainee could be there for 2 or 3 years, have some health issues. None of that is reimbursable while they're incarcerated from Medicaid. It's all on DOC's budget. Even if the person didn't notify DEVA, they would still consider being covered on Medicaid, then they're not. They wouldn't have any Medicaid reimbursement for their health care while they're incarcerated.
Unless they have a 24-hour inpatient stay.
Yeah, if they're in the hospital for a minimum for more than 24 hours. And then Medicaid would cover that if they're eligible for Medicaid. Welcome to the world of corrections. It's very complicated. So the goal of the 1115 waiver is the DOC would be reimbursed from Medicaid for the medical care of those folks that would qualify for Medicaid. If they're not signed up for Medicaid, does that 1115 waiver help at all in getting those folks signed up for Medicaid so when they re-enter, they have insurance?
It will help because we're building all this functionality as a result of the 1115 capacity funds that we have, and we'll also have VCCI staff in place to make sure that people are connected to making sure that people have a good reentry plan and can enter the community with as much stability around their healthcare needs as possible, which is why case management is such a big component, because VCCI will be with them pre-release and they'll also be with them post-release.
And if when person's coming in as a detainee, and there will be somebody there working with the person to see if they do have insurance, if they do currently have a Medicaid policy, to make sure that that is on hold, paused, or suspended, not canceled, so that even if as a detainee, they're there for 2 years as a detainee, when they're released, their coverage automatically kicks in.
That's the goal.
That's the goal. So if we do that when they're first coming in as a detainee, and then they get sentenced, and then they're there for 5 years, and 90 days prior to their release, DOC will be able to receive Medicaid funding for healthcare for that particular individual. And because they're already in the queue when they came in as a detainee in your system, when they're released, you kick their policy back up as active.
Yes.
That's the goal.
Yes.
Folks follow that one?
Yep.
Yes. Questions?
No, but I understand it more today than I did yesterday. Well, especially because the 1115, the part you clarified that it's about the state getting the dollars in 90 days before, rather than, signing them up. It's not the understanding I had, so I learned something. That's not the only thing I learned, but
So I guess I do have a question. You would, for anyone that is being detained, you're trying to sign them up for Medicaid? Is that what I heard you say?
For people who are in the custody of corrections, we are working to get them enrolled in Medicaid, yes.
No matter how long they're gonna be there.
If they're gonna be there for a very long time, then it might not make sense to enroll them
Oh,
if they're sentenced. Because they would have to go through renewals, and it might not make sense to have someone who has a 20-year sentence to push them through renewals every year. But if they're there being detained and are gonna be released in a month or 6 months or 8 months, then we're gonna get them out.
okay. I'm glad I asked the question. So it's reverse. Your focus is trying to get them on Medicaid if they are a short-term.
Yes.
Or if they're towards the end of their long-term sentence, to get them enrolled as well.
before they go out the door.
Right.
So when you're on Medicaid, you have to renew it every single year
Yes.
because it's based on your income. It's not like your regular private insurance. Or it's not like Medicare. Medicaid is driven by a person's income.
Mhm.
So you have to update that every year. So one year you might qualify for Medicaid. Following year, your income has increased to such a point that you don't qualify
Mhm.
for that. Could you go into what the income qualification numbers are for a single person or a family of three offhand?
Are you one of the committees that has the FPL chart posted?
You don't work in
Upstairs
that
does.
world.
You don't work in that
I
world.
think for a single person, it's probably 18,000.
I think you're about right. It's 138% of the federal poverty level is what the income standard is if you're an adult.
And it's your adjusted gross income,
It's your modified adjusted gross. income.
modified
Yeah.
adjusted
Yeah.
gross income. So it's not the first amount that you get, it's after some of the deductions.
Yes, and I believe you're right. It's right around 17 something for a single person. I believe it's around 40 for a family of 4. But I definitely rely on that chart more than me.
It says it's 21,597, but doesn't mean it's right.
For a single. person.
138%.
It says
138%.
138% of FPL is commonly used for Medicaid. The states with expanded Medicaid coverage,
Which
single
we
adult,
have.
contiguous, blah, blah, blah. 138 FPL in 2025 is 21,597 per year. However, this varies based on household size and location, but that's for single.
Per single. So the person who's a single who has come in as an inmate in the facility, and they're a detainee, who knows how long they'll be there. But they could get signed up if they make 21,500 or less a year. If they make more, they would not qualify for Medicaid.
If they are a legal US citizen, yes. Legal resident or US.
So one big question that came up yesterday that people were surprised in,
The AI.
the DOC doesn't ask for their social security number or doesn't have their social security number. They need their social security number to sign up for Medicaid. So it would be a caseworker within your world that would be working with that person to sign them up for Medicaid. Or
CCI or DOC, we're
What's the first acronym?
Vermont.
Vermont Chronic Care Initiative. Isn't that lovely? It's a real
I didn't know
mouthful.
I didn't know what it was. Thank you.
Yeah, no, I have to think about it every time I say it. We are still working through the process, like workflow and processes for who's doing what between VCCI and existing DOC caseworkers. So I think if we were to come to you next session, we'll have it really dialed in and can really walk you through the day in the life. Right now, we're still very much building the plane.
So that DOC would have access to that application form as well as you folks, the BCCI folks. So it's the application form but it's not an application form that the DOC, that's part of the DOC world.
Right, it's Medicaid eligibility.
Does that make sense to folks?
Mhm.
I know, Kevin, you're having a hard time.
Listen, I was gonna say, don't get him going on social security.
Not going there again.
You had to do it.
I wanted to ask the question. It came up.
You did.
It came up yesterday. Because some members were surprised that DOC doesn't
It's kind of weird.
keep track of their social security number, but I don't know why they would really need it.
Because they want to sign them.
I just have to give my social security number for Little League baseball. I just have to give my social security number to sign up for Little League
I
baseball.
think that was Kevin's point.
There you go.
You give it for everything.
Corrections would have-
Do it.
it would seem
That's what's in
correct.
my mind.
You use it for everything. So that was kind of surprising to me that they
The
did.
most basic information about a US citizen is their social security number.
Not to get going on that topic
Oh, come
again,
on.
but I get, yeah, let's go there, but I get the digit at first and then transferring it to that other number, but it sounds like they don't even get the social security
No,
number.
they don't.
So that's what's so confusing. I don't even see a linear pattern. It's just like, oh,
Yeah, it's.
'Cause they could even do the
It's-
last three numbers.
Yeah.
Last four
Last
numbers.
four.
Last four, I
It's the
mean.
most basic identifier in
But that
America.
may change. I don't know. I mean, that's something we could find more with DOC, because we had Isaac here. Maybe Isaac wasn't aware of everything that happens on intake. We could ask DOC for an intake form, because there is a form that has to be filled out
Sure.
at intake, at booking. So we could
Mhm.
ask for that. To see.
And they ask, will we receive it?
Yeah, we'll get
Have
it.
faith.
We'll get it. They'll probably tell you it's on the webpage.
Just got.
I don't trust it.
I question,
We all mixed.
Get it
Do
right
you
on?
have a question?
no,
Kevin?
I'm not. Oh.
Did we confuse you? No.
She's the expert. She can use.
What else are you gonna tell us about Medicaid while folks are incarcerated or that world?
What other questions do you have? I'll tell you, it's a big undertaking. We're working hard on it. It's a lot of moving parts as you're identifying. We have a pretty big team who is committed to getting this off the ground. We have committed to the federal government that we're getting it off the ground on 1/1/2026. We need to meet that deadline. It's why the IT is so important, because even though there is an 1115 waiver that is above and beyond anything that's required by the federal government, it's discretionary. There is a component of the federal statute that says for individuals under 19 and former foster individuals up to age 26, they have to have pre-release services as well. And that actually went into effect in 2025. The federal government understands that states couldn't meet that 2025 deadline, given when the statute passed and how long it took to implement. And so we've committed that we'll meet that kids former foster requirement for pre-release in 2026. At the same time, we'll do it for everyone else. So that date is really key.
Is that 1/1/26?
One.
So
Change.
my question made me think of this. So somebody gets somebody's in a correctional institution, so they're not eligible for Medicaid. Now, my question is, so if they have, say, 2 kids, are the kids still eligible for Medicaid, or is it there? You don't automatically lose the entire thing because
Mhm.
you're in? Okay, so
Because
I
they
just-
have individual policies. Your
I thought so,
policy
but I-
with Medicaid is for you,
yeah,
yourself.
what just made me think of it. So
You
Yeah,
yourself,
that's a
for your
fair
family.
question.
I thought so, but then I was like, well, you know, I have you here, and then Alice already knew the answer. I guess I didn't need you here, but
You need her.
I figured, you know, clarification because
Yeah, you wouldn't lose it. for
I
the
started
family.
wondering, you know.
You wouldn't
now-
lose it for the family.
Okay,
Well, I'm glad you asked the question because I didn't know that. So if a person who's incarcerated, who was eligible for Medicaid, their family still has access to that coverage.
so we're just being told.
Yes, absolutely.
I thought so, but then I started second guessing myself as we were talking. So
well, yeah, that individual loses the Medicaid. Yeah,
No, family,
they keep it.
but it would be in the individual family members.
Individual family members who aren't in corrections will
Right.
have their Medicaid policy. Yes,
But
absolutely.
the family would have to come in under the 40,000 per year. If that's the 150%.
Person who was incarcerated was still part of the household, which now you're getting
Right.
outside of my lane. Their income would count if they're not considered part of the household. It gets really complicated when the individual who's incarcerated is considered head of household, and we're working through.
And that's where I was going. I was like, let's say it's.
People do not lose
I was
coverage.
just gonna say, like, say it was a single mom. It could be a dad, but single mom has two kids, maybe the kids are maybe a grandma or something, but I didn't know if they were still covered or how that worked. That's why I was just kind of curious about that. Thank you.
What happens on the reverse side? So you got a family of three. The head of household that they were not on Medicaid. Head of household becomes incarcerated. And their income for that year their income qualifies them. Would it be just for those two folks who are left at home? For a family of three, because
Would we only be counting the family of threes, the two people's income instead of the three people's
the
income?
head of household is incarcerated.
Right.
So they lose their income. So
Yeah.
at a household, say they just had one income coming in. And the head of household was incarcerated. And they were going to be there for a few years. The family would now qualify for Medicaid, but it would only be the two who were at home, correct?
If the two, I just want to make sure I understand your question. If the two who were at home applied for Medicaid, they would be eligible. Yes.
But to be given Medicaid, the individual has to apply, or can the head of the household apply for the family? Sorry, I don't.
If the head of household is incarcerated,
That's what I'm saying.
They wouldn't be applying.
they wouldn't be able to,
If
it would be the other parent, it would be the other adult in the
The other
household.
adult in the house would have to. Okay.
It was grandma. Yeah.
So then I gotta come full circle. I thought you were saying that when people enter and are incarcerated, you encourage them to sign up for Medicaid when they come in.
That's right.
So if they're in there for 5 months and they successfully get signed up, what value is it? Because they're gonna have to sign up again
In a year.
in a year.
Yeah, but when they're released, they're on Medicaid.
While they're in there, they're not getting any benefit for it, right?
But the key is when they're released, they have insurance.
Yeah.
So if they're on medication, they can get their medication. Or if they need to see substance use, a hub and spoke, they're covered.
Yeah, yeah.
That's the issue, because what was happening before, they had no insurance. And it would take a few months to get insurance, and some of them wouldn't even know how to qualify for Medicaid. A lot of folks don't even know how to apply for Medicaid.
Yeah, the coming out part, I understand, we help them do that, but it's on the way in, what's the value of signing them up if you don't know how long they're gonna be in there and you don't have any claims because they can't claim.
Well, often we don't know how long someone's going to be there. So they might be there for a day, they might be there for 6 months. We don't really know, and we don't necessarily have any runway when they get released. It's like a judge says you have to release this person and they're out that day. So it's a time where they're filling out all this information already. They're getting their medical evaluations done at intake. It's a just good touch point for those individuals to make sure that we're capturing them then, so that if they do get released in 2 weeks or 2 months, we've got them.
So the majority, you're banking on the statistic that most will get out in less than a year because their application is still valid within that year and you want them to be on Medicaid.
Yeah.
I got it.
So once they're on Medicaid and then the renewal time comes up, you get that in the mail.
Yeah.
That you're up for renewal. And then you have to fill out the forms. Has your income changed? Has your household changed? Is there other income coming in the household that wasn't coming in before? And then you send that in. So it's reviewed on a yearly basis for anyone who's on Medicaid. So what's the contingency plan if the 1115 waiver is pulled?
Well, we're not anticipating the 1115 waiver being pulled right now. If we don't get it renewed when it is up at the end of 2027, then we would no longer be able to receive federal funding for those pre-release services, which is 2.7 million a year that we're getting in order to pay for these services. So that would be a loss of federal funding. We have not seen anything to indicate that reentry waiver authority is on the chopping block. It's got pretty bipartisan support. There are many, many states across the country, regardless of blue or red, that have reentry waivers. There are some waivers that I think are very ripe to potentially be cut. Reentry is not one that we're hearing about.
What if Medicaid dollars are really pulled back from the state? I mean, this is all within our global commitment. So what if a lot of that is pulled back? Then what happens?
Well, this is actually one of the few areas where this is money coming into the state instead of money going out. So we're paying for these services anyway, and we're getting matched for the first time. So if Congress cuts Medicaid's budget, then we'll have to find cost savings in other areas of the Medicaid program. But this is actually a revenue source for us, not an area of cost savings to be achieved.
So we'd be spending the 2.7 million anyway, but with the 1115 waiver, where Medicaid would reimburse the healthcare costs, it would be a savings to our DOC budget that we've already would have to pay anyway.
So one of the things in the 1115, it requires you to reinvest any federal funding that you receive. So if this disappeared, it would be up to the legislature to decide if we still wanted to reinvest funding. Maybe things like VCCI caseworkers would go away in the future, but otherwise, those services that we're providing within corrections are going to still be there.
Thoughts, comments?
Oh, man.
It's really helpful background.
Yep. Thank you. I appreciate it.
Medicaid world is complicated.
I strongly suggest that you weekly, as the IT is going out and they're testing it, make sure they're testing it and you're getting reports. I was on a PROPS the year that they were rolling out the IRS, or the tax department was rolling it out, and actual returns for folks sat in boxes for like 8 or 10 months. So I don't say that to friends. Be right on top of it.
Yeah.
Most of us were here when the Green Mountain Care Board launched the exchange.
Yes, I mean, so I just.
It wasn't the Green Mountain Care Board, but the Green Mountain Care,
Right.
the exchange, how that kind of worked. And some of us have been trying to update the Agency of Human Services eligibility. I forgot what that was called, that whole program.
IANE, integrated eligibility.
Yeah.
We're still doing it.
For millions and millions and millions of hours. And we started that over 10 years ago, over that. But that's because we have the old legacy system.
Won't get into unemployment.
Anything else before we
No,
finish
ma'am.
up here? I hope this has been helpful. I hope it hasn't
Thank you.
offered more
Thank you.
confusion. I hope we weren't too confusing for you.
She's got this.
Hopefully you'll have us back next session and we can report out on the successful IT launch and all the people that we're enrolling. Maybe we'll have social security numbers by then.
Don't get him started.
So, thank you.
Thank you so much.
Really appreciate
Thank
it.
you.
For the rest of the day.
Thank you. Oh, so is the committee all confused?
No, actually, very fine. Good. Very good.
Tell me, now this is, oh, well, I guess we're online.
So,
Better tape.
we'll work to set up some schedules for, rather bill for that second look. We'll work on setting up schedules for next week
Mhm.
on that. I don't know where the capital bill is, over there. I know they're working on it.
That's going smoothly.
Yeah, I'm thinking, it was funny, I think they had the target for this Friday to get it out, but I saw a senator on the committee and asked him, and he says no. So I don't know what's gonna happen,
We'll find out.
but we'll find out when we find out. So we're done for today. We're back here tomorrow morning at 9 o'clock. And we have a pretty full day tomorrow.
What are we starting with tomorrow?
You ain't done battle monument.
No.
Yes.
Can we turn off?
Okay.
Can we turn off?
Yeah. So we have a full schedule tomorrow, and I don't think we'll be on the floor very long either. And one thing we will be getting into tomorrow that we haven't heard much testimony on is 349, which is the Building Security Board.
Mhm.
We're gonna be looking at that with the Commissioner of BGS as well, so judiciary, to see if that's the bill we want to work on
Mhm.
or not. But we couldn't get the Commissioner of BGS in here until this week.
Mhm.
So we didn't want to do anything on that until she could come in.
I'll point out that DOC won't be able to be here until 3:15
Tomorrow,
tomorrow. So there'll be a gap between when you get off the floor.
right?
Okay.
That's fine.
Okay,
This is coming from.
Avia Teva and their legal counsel, Emily Carr.
It's about their medical bill, but
No.
each 32.
No.
Yeah.
Are those cars still down south? Is she zooming in?
You all right?
Am I
Are
okay?
we
Oh.
done?
No, this is my like silence signal.
Done?
Ixnay on the estrogen's way?
I think we're ready to go.